Guys, thanks for watching this video. I am Melky and I'm going to read the binding arbitration and class action waiver part of the Microsoft Service Agreement in this video. Thank you very much, and please notice that I'm doing this for casual purposes, just so that I could connect with people and explore the world through this lens. Excuse me for my hair, I don't like it. And therefore the context is not a professional advice. I am not offering any professional advice in what kind of discipline or whatsoever for any kinds of intents and purposes. And please consult your professional advisor if you need some kind of business advice or high stakes advice. And even if you want to believe this, you should process it again every time you want to make a decision, because I am not giving any kind of assurance, professional assurance, that is reliable. Yes, just that. It's just an exploration and fiddling around, a lot of assumption and a lot of experimentation and exploration of ideas. That is the purpose of this video, to connect with people and just be casual and having a journey, probably back and forth as well, just so that I have a better understanding and a better tools to protect my properties, and to understand what are my limitations, and you know just but casually for personal purposes. I hope you can get a benefit from this as well. And let's start. Binding arbitration and class action waiver. Binding arbitration and class action waiver if you live in, or if a business, your principal place of business is in the United States. We hope we never have a dispute, but if we do, you and we agree to try for 60 days upon receipt of a notice of dispute to resolve it informally. If we can't, you and we agree to binding individual arbitration before the American Arbitration Association, or AAA, under the Federal Arbitration Act, FAA, and not to sue in court in front of a judge or jury. Instead, a neutral arbitrator will decide, and the arbitrator's decision will be final, except for a limited right of review under the FAA. Excuse me guys, there are noises, background noises. Let me just turn that off. So that is just me. I'm sorry. Next, instead, a neutral arbitrator will decide, and the arbitrator's decision will be final, except for a limited right of review under the FFA. Class action lawsuits, class-wide arbitrations, private attorney general actions, requests for public injunction, and any other proceeding or request for relief where someone acts in a representative capacity aren't allowed. Wow, anyway, there are some things that I wanted to say about this. I don't live in the US, so this is supposed to not be applicable for me, legally speaking. I don't know whether, if there's a dispute, what are the means that are going to be used with between Microsoft and people like me. And also, what am I going to say? But it is nice that they are aware, to know that they are aware of certain stuff and certain aspects. It's nice to know what are my limitation, like for example, class action lawsuits right here. It is nice to know that they are uncomfortable with it, but I do believe that every, like in the US, you have your own way of defining things, and for me, I wouldn't be able to fully have a standard or casual view of what some of this jargon means in your country, or in the citizen of the US country. I assume all. Yeah, and for example, class action lawsuit, isn't it not nice actually, to not being able to do class action lawsuit, especially if you are so small against a multinational company like this? I think that is not nice, but I don't know. I don't know. Probably that could cause a lot of problems with international relationship and business relationship as well. There's got to be a solution to that. Next, no, nor is combining individual proceedings without the consent of all parties. We, our, and us includes Microsoft and Microsoft affiliates. A. Disputes covered everything except IP. The term dispute is as broad as it can be. It includes any claim or controversy between you and us concerning the services, the software related to the services or software's price, your Microsoft account, advertising, marketing communications, your purchase transaction, billing, or these terms under any legal theory, including contract, warranty, tort, statute, or regulations. Except disputes relating to the enforcement or validity of your licensors, our or our licensors in intellectual property rights. Except disputes relating to the enforcement of validity of your licensors, our or our licensors intellectual property rights. So there's going to be that in here. Otherwise than that, or that would not be covered in here. Other than that, it would be, wait a minute, it would be covered. Okay, IP would not be covered except for this kind of IP. Wait a minute. The term dispute includes advertising, marketing, communication, except disputes relating to the enforcement of validity of licensor intellectual property rights. So IP is the exception. IP there, and this particular IP, there no this particular IP. This is just IP. So that was my misunderstanding right there. It could be misleading. I'm sorry. uh, and then in IP related, that means there are other licenses, probably the ones that I've read above here. Is talking about IP, likely not comprehensive all of them, so there would be some other things that are related to IP as well, copyright notice, and other kinds of policies that Microsoft implemented. Would that be all in the service agreement though? I'm not sure. Yeah, as I said, I would think that there are other licenses as well related to IP, as well as the intellectual property laws, or as well, of course, is the one that is the most relevant here. And this I'm sorry, that was annoying that sliders went up and down, like that. I don't know how to turn that off. If I could, I would turn that off. And in terms of IP, I think the intellectual property law is the most relevant here. Of course, there are other things that are more relevant than that, but just for the sake of the conversation, like the priority of this scope would be the IP law. Next, send a notice of dispute before arbitration. If you have a dispute that our customer service representatives can't resolve and you wish to pursue arbitration, you must first send an individualized notice of dispute to Microsoft Corporation. Attention, Sila Arbitration, 1 Microsoft Way, Redmond, WA. Okay, I'm not going to read everything. These are the address, or submit the form electronically. The notice of dispute form is available at, there's a link there. Complete that form in full with all the information it requires. We'll do the same if we have a dispute with you. This notice of dispute is a prerequisite to initiating any arbitration. Any applicable statute of limitations will be told from the date of a properly submitted individualized notice of dispute through the first date on which an arbitration may properly be filed under this section 15. C. Small claims court option. Instead of sending a notice of dispute, either you or we may sue the other party in small claims court, seeking only individualized relief, so long as the action meets the small claims court's requirements and remains an individual action seeking individualized relief. The small claims court must be in your country of residence, or if a business, your principal place of business. Okay, arbitration procedure. D. The AAA will conduct any arbitration under its commercial arbitration rules or if you are an individual and use the services for personal or household use, or if the value of the dispute is less than 75,000, whether or not you are an individual or how you use the services, it's consumer arbitration rules. Okay, this is in the bracket, right? Let me read that again without the in bracket part. The AAA will conduct any arbitration under its commercial arbitration rules. For more information, see, there's a link there, adr.org, or call, there's a number there, 1-800 number, and section 15, and these terms govern to the extent they conflict with any applicable AAA rules. Section 15, and these terms govern to the extent they conflict with any applicable rules, any applicable AAA rules. To initiate an arbitration, submit the demand for arbitration form available at, there's a link there, gomicrosoft.com, to the AAA, and mail a copy to us. The form must contain information that is specific to you and your claim. In a dispute involving $25,000 or less, any hearing will be telephonic or by video conference. Unless the arbitrator finds good cause to hold an in-person hearing instead, any in-person hearing, instead, okay, instead, right there, any in-person hearing will take place in your country of residence. Or if a business, your principal place of business. Is this for US only? Wait. This is not for US only. Wait. If you live in, or if a business, your principal place of business is in the United States. Oh, principal place of, okay, principal place of living, but you are located overseas. So like a overseas worker or overseas manager. Okay, where was it? The arbitrator may award the same damages to you individually as a court could. The arbitrator may award declaratory or injunctive relief only to you individually to satisfy your individual claim, but not relief that would affect non-parties. Okay, that is the scope. The arbitrator rules on all issues except that a court has exclusive authority to decide arbitrarily, as well as formation, existence, scope, validity, and enforceability of this arbitration agreement. To decide whether the parties have complied with the pre-arbitration requirements, including the individualized notice of dispute and demand for arbitration forms. To enforce the prohibition on class, representative, private, attorney general, or combined actions or proceedings, or public injunctive relief, and to enjoin an arbitration from proceeding if it does not comply with this section 15. If your notice, something's here. The arbitrator rules on all issues except that a court has exclusive authority to decide arbitrarily, to decide whether to enforce, to enjoin the arbitration proceeding, and it does not comply with this section 15. If your notice of dispute involves claims similar to those of at least 24 other customers, and if you and those other customers are represented by the same lawyers or by lawyers who are coordinating with each other, you and we agree that these claims will be related cases. Related cases may only be filed in batches of up to 50 individual arbitrations at a time. So that is good. So previously we read about class action being exempt by being, what does it called, being relieved, being like you release your rights or something like that. Maybe not also, maybe not the same, maybe not the same. The point is they want to avoid class action, right? But this one, related cases, is like that. So I assume all collective cases are class cases, but this one is another collective cases as well. So I didn't understand. Here comes related cases may only be filed in batches of up to 50 individual arbitration at a time, and those individual arbitration will be resolved in the following manner. For the first batch, each side may select up to 25 of these related cases to be filed and resolved in individual arbitrations under this section 15. From 50-25. None of the other related cases may be filed or prosecuted in arbitration until the first batch of up to 50 individual arbitration is resolved, and if after that first batch the parties are unable to informally resolve the remaining related cases, a second batch of related cases may be filed, where each side may select up to 25 of the related cases to be resolved in individual arbitration under this section 15. This process of batch individual arbitration will continue until the parties resolve all related cases informally or through individual arbitrations. A court has exclusive authority to enforce this paragraph, including whether it applies to a given set of claims. And to enjoin the filing or prosecution of arbitration that do not comply with this paragraph. Wow. E. Arbitration fees and payments. Disputes involving less than 75,000. We will promptly reimburse your filing fees and pay the AAA's and arbitrators' fees and expenses if the dispute involves less than 75,000 and before initiating arbitration. You complied with all pre-arbitration requirements. So before initiating arbitration, you complied with all pre-arbitration requirements in this section 15, including, if applicable, the related cases paragraph. Otherwise, the AAA rules will govern payment of filing fees and the AAA's and the arbitrator fees and expenses. If, at the conclusion of the arbitration, the arbitrator awards you more than our last written offer made before the arbitrator was appointed, we will pay you the amount of the award or $1,000, whichever is more, and for any reasonable attorney fees you incurred and any reasonable expenses, including expert witness fees and costs that your attorney accrued in connection with your individual arbitration. The second one, disputes involving 75,000 or more, the AAA rules will govern payment of filing fees and the AAA's and arbitrators' fees and expenses. Okay, wow. F. Rejecting future arbitration changes. You may reject any change we make to section 15 except address changes by personally signing and sending us notice within 30 days of the change by US mail to the address in section 15B. So I would assume this is rejection to arbitration and you want to go straight to the court. If you do, the most recent version of section 15 before the change you rejected will apply. Is this the section 15? Yes. Well, probably not exclusively that, right? But it could be that. Okay, I was not being accurate. Next, sufferability. If probably G. Sufferability. If after exhaustion of all appeals, a court finds any part of this section 15 unenforceable as to any claim or request for a remedy. Oh, I see. Yeah, you can kind of modify the arbitration agreement up front by sending a mail like in this F section here within 30 days of the change. Interesting. So, okay, next. This is again not not common for me supposedly. If after exhaustion of all appeals, a court finds any part of this Section 15 unenforceable as to any claim or request for a remedy, then the parties agree to arbitrate all claims and remedies subject to arbitration before litigating in court any remaining claims or remedies. When do you go to court that the court will find it unenforceable? Before litigating in court any remaining claims or remedies. So you litigate in court for some initial claims first, in which case the arbitrator issues an award on liability and individual relief before a court considers that request. Okay, that is nice actually, because you already know what the court wants, what the court stands on it, rather than going to court again. That's nice. Otherwise, if any other part of Section 15 is found to be unenforceable, the remainder will remain in effect, with an arbitration award issued before any court proceeding begins, with an arbitration award issued surely, however, though, before litigating in court any remaining claims or remedies, which as request for a public injunction remedy, in which case the arbitrator issues an award on liability and individual relief before a court considers that request. I don't really understand this, but it is interesting in a way that I you know what, I'm not going to go into that. Let us go to the other part. But but just so that I would remember that that there's some convolution. What is it that I was, how can I express this? That would be the end of the video, right? How do I conclude this last part? I want to conclude something in here, in terms of arbitration, and I'm going to talk about just from the point of view of me as a world citizen. Just kidding. As someone who is not in the US, first of all, being in the arbitration, I have no experiences of it before. My question would be, how would Microsoft deal with cases in overseas? And there could be some issues if there are different, if the same issues is faced with people from multiple countries. So should the people from the US use arbitration while some of the other people from overseas uses their court proceedings? And could they all, they wouldn't be able, that would be violating jurisdiction to ban them all together. But is there an option to international arbitration or something like that? And I think it is not illegal to have some kind of international arbitrage, right? As long as it's like a negotiation, but probably you wouldn't call it with the terms that are associated with local laws. probably it would be something else, but still it's something like that. And then in case of precedences, as Microsoft, you would want to rule out confusion because of precedence, but also being inconsistent means trouble. Like, not interesting, this is complicated. Yes, definitely complicated. It's really hard for me to express the problem in this thing. It's problematic. Yes, I think it's problematic. mm. Can you guys give me a little enlightenment or something? The concern here is, okay, let me put this like this. Sorry for all of the delays with that. Let me just put it like this. It is nice to have some kind of counsel for a company that has a monopoly in something. It is nice to have some kind of stakeholder council in their board. And this stakeholder council would have a say also in the policy making, for example, in especially in relation to outside interest or third party interest, non shareholder interest. It is also probably could be started by everybody who's related to have access to even 0.01% of a monopolizer's share, so that, I don't know, would that make them eligible to have a voice? Maybe not actually. One share per voice, right? uh, yeah, it would be nice. Like, I would want that. I want to be able to have more voice in the policies that are going to affect my life. uh yeah, and in relation to this severability again, as an overseas user. Yeah, okay, back to that again. It would be nice to also have some kind of representative or something in the board of uh, in the board of the services that I rely on for my life. I would be making more videos for, like, I am planning to make more videos in relation to this to the terms, but again, please take it with a grain of salt. The decision making made based on my opinion as an individual and as a person who is lacking of experiences and probably the prerequisite minimum knowledge and expertise on this issue would be reckless, guys. I would just want to have a conversation and improve myself and improve my knowledge. Um, but also, at the same time, I would like to be able to protect my own property when I could, and also actually have a better property, or probably growing my property. um, for this video, thank you very much for watching all this time. It's half an hour and a little bit less. Hopefully you could benefit from this, and if not, I would want to be able to benefit you in the future, in a just kind of way. Goodbye.